Okay. All right. We will get started. Good afternoon, everyone, and good morning to some of you out on the West Coast. It's great to have you here. Behalf of the entire team here at Hudson Headwaters 340B, we welcome you to our quarterly webinar series. My name is Mike Fish. I'm the Vice President of Client Success here at Hudson 340B, and joining me on the webinar today is we have Rachel Sari, who is our Client Success Manager, and we also have Felicity Homstead, CEO of FQHC 340B Compliance. So we're excited to have Felicity joining us today. Felicity has a wide range of 340B experience and is a great asset to the 340B program. She'll be covering a wide range of topics today, hot topics in 340B. So we're excited to have Felicity. Before I do hand the floor over to Felicity, I just want to walk through a couple of logistics regarding the webinar. We are encouraging a Q&A session. So if you do have questions, please, on the top bar of the webinar, you'll see a Q&A icon. Click on that, and Rachel is capturing all of the questions. And we're going to leave plenty of time at the end of the webinar for a Q&A session with Felicity. So please pop any questions in there, and we'll get to those at the end of the presentation here. Looking forward to that portion of the webinar. We will also be recording the webinar. So for those folks who cannot attend, any team members you have that couldn't join today, we'll get this recording shared out by the end of the week or early next week at the latest to share with your folks. And then lastly, just a final comment here from not just the client success team at Hudson Headwaters, but the entire organization here at Hudson 340B. We realize it's a extremely busy time right now. There's a lot of activities with the 340B program. It's the middle of summer vacation season and schedules and whatnot. So, just want to offer a word that we really appreciate you taking the time out of your day to join us for this webinar and listen in. We think there's some really relevant topics. And, Felicity being the expert on many of these, we're thrilled to have her here and share her knowledge with our client base here. So Felicity, like I mentioned, the CEO of FQHC 340B Compliance, though I don't want to limit her capacity to FQHCs, as she supports hospitals as well. So to our hospital folks on this webinar, there'll be a lot of relevant content for everyone here. So we're looking forward to that. So there's a lot going on with the program currently. We're doing our best to keep up with everyone and keeping everyone apprised of the most recent developments and changes to the program that seem to be coming at us every single day. So doing our best to stay on top of these and share this information when we can. And part of that sharing is through these webinars that we conduct quarterly. And having a special guest like Felicity on today is just part of that offering. For everyone, for all of our clients. So, Felicity, without further delay, let's get to the meat of the content, and I'll hand it over to you. The floor is yours, Felicity.
Awesome. Thank you, Mike. And it is lovely to see everybody here today. I am going to attempt to share the presentation through Teams. A couple disclosures. One, the bookshelf behind me is real, frequent question. Two, this is sparkling water. Also have gotten questions previously in presentations about what am I consuming. It's just water. And so if I have not met you before, it's lovely to meet you. I started my career in 340B at a DSH hospital, spent 6 years there, did 6 years at a federally qualified health center, spent 3 years as an auditor, auditing all types of 340B programs. So just about every single covered entity type, except for the really rare grantees I have worked with. And then most recently have been focused on primarily FQHCs, but also hospitals and other grantees are our clients as well. So let's jump in because, as Mike said, there are a lot of things going on in 340B. And it does not slow down. So Mike gave me a laundry list of items that he would like to present on. And so I picked my favorites because I'm the presenter. So that is my prerogative. So we're going to see what happens. Ooh la la. It appears to be working. Are you all seeing the presentation looking like a presentation?
Looks fantastic, Felicity. Good to go.
Okay.
Yep.
Beautiful. Because on my side, it's looking like presenter and possibly notes. So I just want to make sure your view is the right view too. Okay. So that's me. You can see me, and we're going to be talking about hot topics. I had hoped to give you a preview of what was going to be in there, but right up until the last minute, we were getting these refined. So if people, you've just met me, if you would like to introduce yourself in the chat, 340B friends and family, that's for the Hudson Headwaters people as your TPA. But then others, if you'd like to introduce yourself in the chat, it'd be great to get to know you as well. And then we're just going to jump in and start talking about hot topics. So one of the biggest areas that we have seen a lot of covered entities have questions about is the AMP cap removal. Each topic that we cover, I'm going to try to keep it concise just because we have so much to do, but just give you the information that you need to know, the highlights. And so this may feel a little bit fast-paced, and I'm going to rely on Rachel to give questions as they come as well. But so the AMP cap removal, the most important thing that you need to know about this was that there was legislation that was put into place, and so it was the American Rescue Plan Act, which took away what we refer to as the AMP cap away from the Medicaid rebate. And so the best way to explain this is to use an analogy. Within 340B, we are all very familiar with the 340B ceiling price. And so when inflationary penalties are applied to the 340B calculation, it can go up to the point of a penny pricing where we're paying 1 penny per unit. And that's the maximum that the rebate inflationary penalty can go, or sorry, the inflationary penalty on 340B calculation can go to. In the case of Medicaid, they used to have what they called the AMP cap, and that was saying that a similar situation, they could not go below 0. Now that they have removed the AMP cap, what has happened is that the calculation just goes with inflation. So if the drug manufacturers escalate the prices faster than inflation, there could be scenarios where the manufacturers actually ended up paying Medicaid to take their drug. And so in this example that's calculated out here, there is a situation where Medicaid may actually have made $50 on having a drug dispensed to their patient. And that would be that beyond what Medicaid paid for the dispensing of that prescription, the manufacturer actually rebated Medicaid more than was paid. So Medicaid made money off of the dispensing of the drug, which would be lovely for Medicaid, except for the manufacturers are very business savvy, and they accounted for this change before the law was implemented. And so we saw a lot of shifting of prices towards the end of 2023, early 2024. And what we're seeing now is the catch up of those in the 340B prices, because it takes 2 quarters for a change in the regular market to actually impact the 340B ceiling price calculation. So when you're looking at what are you paying for a 340B price drug, you may notice that there are quite a few items, especially insulins and inhalers, that penny pricing is no longer there and the price is higher. And that's a direct result of actually this AMP cap removal. So the manufacturers reduced their list price of the drug to avoid those inflationary penalties. And ultimately, that raised the 340B ceiling price because it also avoided inflationary penalties on the 340B ceiling price calculation. So this is a great example of, by lowering the top price or the market price that the manufacturers were charging, they actually saved themselves hundreds of millions of dollars. Likely they lowered the amount of rebate that they were offering on the back end, and ultimately kept themselves whole or created savings. So they've adapted to this. Other things that we anticipate seeing in the market, both from this AMP cap rule as well as IRA, which we'll talk about towards the end of the presentation, is that new drugs coming to market will have higher list prices, and that will be to avoid inflationary penalties. Because the inflationary penalties are so steep with new changes to legislation, manufacturers are going to be highly incentivized not to bring drugs to market at one price and escalate over time, but instead bring at a higher price and be more stable in how they're increasing their prices. So this is just a quick overview of what the implications will be. We've talked about it, and so I won't go into that too much, but just know that as we see more drugs attempting to adapt to the removal of an AMP cap, that we may see more increases in our 340B acquisition price as well. All right, manufacturer restrictions. You haven't noticed these are happening. Congratulations to you. You are probably the only one out there. They started in the summer of 2020. Eli Lilly was the first, and they started the restriction with Cialis. And we all had that feeling that this was the beginning of something concerning, and very quickly after that, we saw more manufacturers following suit. We did see HRSA coming in with letters to the manufacturers attempting to stop them, lots of lawsuits. We still actually have one lawsuit that is pending. So we got the ruling back from the Third Circuit, which ruled in the manufacturer's favor, got the ruling back from the DC Circuit, which again ruled in the manufacturer's favor. Key pieces from those rulings is that there is some language that talks about the restrictions being reasonable, right? And so in each of the cases that were heard, there was a certain set of circumstances that the judges considered. And what has happened over the last few months is we have seen an evolution in the restrictions that the manufacturers are imposing. So the restrictions that we are under today are very different from the restrictions that the manufacturers were imposing in the beginning. However, for us to get a different answer from a judge, or for a judge to tell us whether or not those restrictions are reasonable, it would require litigation all over again. And if you're familiar with 340B in the Supreme Court, AstraZeneca versus Santa Clara, came back with a ruling that we as covered entities don't have an opportunity to sue the manufacturers, only HRSA does. And we'll talk a little bit more about what our pathway is later. But in the last couple months, this is all the excitement that has been happening in the program. And so some of these are new restrictions. So Vertex and Viatris are two new restrictions. Some of them are updates to restrictions, and really we're just seeing a lot of changes. On the positive side, which we'll highlight in a little bit, the majority of what you're actually seeing on this chart is manufacturers who are responding to what is going on at the state level and putting exemptions in place. So not all of these are changes to a manufacturer's policy becoming more restrictive. But there are some that are in a scenario that is very different from what was presented to the courts. And so Sanofi is one that we're keeping a close eye on in how the restrictions have changed. So most importantly, in Sanofi's recent letter, they had some language that was quite accusatory to the covered entities. And so that's what's up in the top box of this slide, suggesting that there was instances of duplicate discounts and questioning program integrity. So they made statements. They in the letter did not bring evidence of that. However, they did change their restrictions. And so if you are a FQHC who had been participating in the multiple site designation process, with Sanofi, that no longer was something that would be open to you if you are a federally qualified health center whose 340B ID starts with CH or CHC, that they were now considering you the way that they considered hospitals. And so you were only able to get one pharmacy, contract pharmacy, if you didn't have any in-house pharmacies for your entire covered entity versus how they're treating all of the other grantees, which is one pharmacy per covered entity location. So that was a big change from Sanofi. The other piece that we are tracking very closely is Bristol Myers Squibb and their update that they provided via FAQ, which is one, looking for all of the information to be submitted to 340B ESP within a 14-day timeframe. And then what's really key in this is also that they have implied that they have asked for 340B ESP to create enhancements to their system. And so the language in this FAQ states that upon enhancements being created, so it says upon platform capability, that the covered entities are going to be committing to providing things like the wholesaler invoice number, in PCN and group number, and another one that we find concerning and possibly difficult to achieve is the product serialization number. And so these are all items that historically had not been asked for from any manufacturer within 340B ESP. And when we met with BMS, they said that their expectation was that covered entities would have replenished all items within that 14-day window. We let them know that that would be very difficult to accomplish, especially if you were a smaller covered entity, and that it was creating a significant disadvantage for entities that were of a smaller size. And we have not heard any response back. I don't anticipate change from BMS, but we did articulate the difficulties that this policy would create. The other thing that we heard from BMS was they anticipate this timeline to be as soon as the start of the next quarter. So this is something that is very important to understand, both if it is accomplishable for your contract pharmacies, as well as what might be appropriate therapeutic alternatives. And so that will lead us into, again, some other important conversations. So this is just visually on the left, what we were being asked for before, and on the right, what we are being asked for now, coming up in the near future. So very challenging, potentially. And so the positive news, right? Huzzah, we've got some of that. That's good. There are some shiny moments in this presentation, I promise. It's not all doom and gloom. These are state exemptions. And so we have seen 8 states so far doing great work in getting contract pharmacy protections passed. And this is the list of manufacturers who have responded. And I believe there is one missing from this list because it does change on a daily basis. So I believe we have, there may be a Kansas one that's missing off of this. So just know that these are constantly updating. Jazz has taken care of that. They've said any state that passes legislation, you're in. But the others are doing it state by state. It feels arbitrary. It may be where they're litigating, where they've lost, but it's completely variable by the manufacturer as to which states they are approving. So now we're going to talk a little bit about litigation, legislation. We're not going to hit everything because there's way too much going on for us to cover it in this time period. I told Mike the list he gave me, it could have been an entire day's content, could have been a week's content. But here's just your high level, and big shout out to 340B Report, who I did make sure I could use this copyrighted visuals. There's a couple of them with their permission. And so within their website, they do keep track of all the states that are approving legislation. And so this chart was one that I added. So it's the order of who signed when, and how many exemptions do they have currently. So again, Kansas may be up to 10, but and then the other caveat is that these are published exemptions. So not all manufacturers are making their exemptions public. They may not want to be seen as promoting the success of the state laws. So ways to find out if there is an exemption from the manufacturer can also include checking in with your wholesaler, checking in with 340B ESP, because they do manage that on behalf of the manufacturers that they are managing the restrictions for. And then also reaching out to the manufacturer is the other way that you can check on that. So it's interesting, right? States that have had success. So Arkansas was the first one, and then we've kind of seen a spread of almost contiguous states for those who have approved. We're seeing really great growth with states who are proposing, attempting to get legislation in place. So this is a really positive trend, and this has also been the most successful strategy that we have seen across the board for addressing the manufacturer restrictions. And there are lots of reasons for that. The high level of the litigation within the states is that the 340B statute does not talk about distribution or delivery, and that pharmacy and distribution and drug distribution are state matters, are seen to be state matters. And so it gives an opportunity for the states to legislate in that area. So this is a lot of information. It's there for your viewing pleasure. We did share the slide deck with Rachel and the team so they can share it with you. We're not going to get into, this is like sort of the weeds of the court case, but this is the most important ruling that we've seen most recently. Okay, so, and this is just the summary. So in Mississippi, AbbVie and multiple other pharmaceutical manufacturers were suing against the legislation that was passed as the Contract Pharmacy Protection. And they had a lot of reasons. One was that they said that the 340B statute would preempt any state legislation. Court did not agree with that. Had a lot of other arguments. But what was new and different that AbbVie brought in this case was arguing that the replenishment model, which we use not just at contract pharmacy, but also in the hospitals and in some entity-owned pharmacies, so it's very broadly used across the 340B space, could constitute diversion. And so the judge did rule on that. And this was very positive. So they asked for a preliminary injunction as well as what was going on in the rest of the case. So in the preliminary injunction ruling, the judge came back and said, one, we don't see, based on the arguments that you have presented in the initial arguments, that there is anything that would be compelling to us to anticipate ruling in your favor. So we're not granting you the preliminary injunction because we don't see the case for that. But also in your specific argument around replenishment constituting diversion, we also specifically disagree with that because there are many instances of replenishment models outside of 340B across the US drug system where the replenishment model is just a natural part of the US drug distribution system. And so that's paraphrasing, but that's essentially where the court came back. So that is wonderful because that was, we were starting to hear a lot of rumblings in the space, and that seemed to be one of these strategies that was evolving. And so if they had gotten this preliminary injunction and the judge had ruled in favor on this, it would have been very destabilizing to the 340B space, because if we had one court rule that replenishment could constitute diversion, you can imagine how impactful that would be to the rest of the country and how quickly pharma would have been moving on that. So other state legislations that we are seeing, just massive work. It started before contract pharmacy protection, and we've just seen really great spread, which is the PBM protection bill. So really great work there. And then the other part where we don't want to see spread, but we are seeing a little bit, is around the reporting requirements. So originally the first two were Maine and Minnesota. Now we have them out in Washington as well. And there are a few other states that are proposing. And so just something to keep an eye on. For the most part, many of the FQHCs already have reporting requirements. There are typically already requirements built into different covered entity types on how we use our savings. But this is something that if we do see federal legislation, that we will have requirements there. So I would be very cautious about anything that came in at the state level, knowing that we will likely have federal reporting requirements at some point in the future. Okay, so we talked about Astra v. Santa Clara. We know we can't sue pharma, but how do we get our day in court? And so effective June 18th of this year, the new ADR 2.0 was approved by HRSA, and they published it in the Federal Register. It's live, it's active, effective as of June. And so they have changed it very intentionally, and the intention that OPA had in this new iteration was the old version was highly litigious, very much functioned as a court proceeding, and extremely burdensome to covered entities to try to independently participate in it without having significant legal counsel and a lot of burden placed on them. The new model, the ADR panel is staffed with OPA members who will understand the 340B program. That's a positive. They will permit claims to be reviewed on the ADR panel that are similar to those pending in federal court. This is so very important because the initial cases that went to the ADR panel were actually put out because there was a similar case pending in federal court. And so this makes it very difficult for any covered entity to have an issue or a grievance heard if we have to wait for 10 years for something to play out in a federal system when only pharma can litigate there, and we don't have an opportunity to be present outside of an amicus brief. So this is a big change for us. The other piece is they promise us a decision in a year. If we disagree, either party can request essentially a re-review, an appeal that will be done by the administrator. And once things leave the ADR, right, once you get that final ruling from the ADR, it is a binding agency decision, you can actually go into court as a covered entity versus pharma at that point, should you choose. More likely it's going to be pharma if you've won, who's choosing to take you that way. But just so you know, that is when we have an opportunity to have our day in the actual court system is by going through the ADR process. So I'm hoping these appear bigger on your screen because they're quite small on mine, but this is just the pathway for going through. So first of all, you have to do your good faith attempt. You have to, as a covered entity, work with the manufacturer to attempt to resolve the issue prior to taking it to the administrative dispute resolution panel. Second, you have to prepare your documentation of what the issue was. Third, you're going to file the claim. The claim is going to be reviewed by the Office of Pharmacy Affairs to determine if it is a valid claim, if they're going to accept it. If they do, they will alert the other party, and then they will actually place that information in a new section of 340B OPACE, where you are able to track and interact with your claim under your logged in user profile. So the AO, the PC, and you can have one other delegate have access to that portion. So this is the first time we're seeing OPA allow anybody other than the AO and the PC into 340B OPACE, and it's around the administrative dispute resolution process. important, claims must be filed within 3 years of the violation. So that's really important. Once they have all the information from both parties, OPA will review it. They will come to a decision within a year, unless there are unforeseen circumstances. And then once you receive that decision, either party could request a reconsideration. That will be done within 30 business days by the secretary. Yeah. Little bit of a snag. I don't know if you guys have heard about just, tiny court ruling that might disrupt the entire US system. But, Loeb or Bright, it's kind of fun. So I've been tracking this for quite a while because I live on the East Coast and we have lots of friends who are fishermen. And so Magnuson-Stevens for Fishery Conservation and Management Act. That was a big act that was passed. It's intended to protect the fishing off of the East Coast of the US, prevent overfishing. Beautiful, right? We highly support that. However, there were some differences of interpretation that happened in the implementation of that act that led to the challenging of one of the most ingrained elements in the US court systems. So Chevron deference, you probably have all heard of this multiple times. That is when an administrative agency gets deference or the preference in the courts if there is if essentially a legislation is written and it says, okay, we're going to give this agency the opportunity to define this portion. We're going to, as Congress, we're not going to fill this part in. We're going to have EPA fill this in, or we're going to have example like what we just talked about, HRSA fill in. How's that ADR process going to work? So just FYI, as far as 340B goes, there were 3 places where we had, where HRSA had regulatory authority. And if an agency has regulatory authority, that would be where Chevron deference would come into play. So civil monetary penalties, ceiling price calculation, and administrative dispute resolution process. So we could see challenges to how HRSA has interpreted administrative dispute resolution process. We shall see. So the Chevron deference had been there since 1984. And essentially, if Congress granted to the agency the opportunity to fill in areas of that statute, then the courts would essentially defer to that administrative agency. And so there were lots of times where either the court would rule in the agency's favor, or corporations, private entities would choose not to take something to court because they anticipated that the ruling would rely on Chevron deference and it would rule in favor of the agency because they had been granted the authority to fill in the information. And so we've seen a trend from the current Supreme Court where they have been ruling less and less with Chevron deference over the last number of years. And they have actually been just going back to sort of what is the document, what's the best interpretation of the document, and ruling on that. But they hadn't been asked to give a ruling on Chevron deference. And so this was the first court case that came to them and really hinged on Chevron deference, because when the Fisheries Act was put in, it didn't say who had to pay for these monitors to be put on boats to monitor the catches. And so when OPA comes in, or Bissell on behalf of OPA comes in to audit us, HRSA pays for that. However, in the case of these fishermen, they were told that they were going to have to pay for their auditor to audit them. And so they did not like that. And that is how this all went through the courts. So ultimately, Supreme Court split decision 6-3, ruled that there is a best interpretation of any legislation, and that when they're making a decision, that they'll still have what's called Skidmore deference, which is the agency's power to persuade and the agencies to interpret correctly, but they're not going to just defer to the agency, that there will be a valid review looking for that best reading. So, but the challenge that that brings is that you can always have a situation now where there are two interpretations, and that second interpretation deserves a day in court to decide which of the two is best interpretation. And I think we're going to get into significant challenges with that in the 340B program in the coming days. Not going to go down that rabbit hole because I did promise you good news. So, good news. Does it feel like good news? Inflation Reduction Act. And I have to be really quick here because we also said that we're going to do Q&A. So I think I have to 45, Mike? 45, yes?
45, yes. 8
Perfect.
minutes.
Okay. So we're going to do Whirlwind of Inflation Reduction Act. And I'm guessing, I don't think anyone has talked about this yet. I haven't seen any talks on it yet because we've been too busy with everything else. So I had fun putting these ones together. Buried in a 2,246-page document of, and there's the official title, Medicare, Medicaid, CY 2025 Payment Policies for the Physician's Fee Schedule. They have put out their proposed rule for 2025. And there is a lot of stuff in here. There is a lot of stuff. So it's how are we going to pay physicians everywhere in Medicare, okay? So there's some really important hospital stuff. There's important ACO stuff in here, FQHC stuff. I mean, there is a ton that is covered in here. I was talking to one person, they said this is the largest one that they have seen put out. I think last year's was about 1,500. Joy. So buried in this document at page 949, in case you decide to pull the document and you want directions on how to get here, is the Inflation Reduction Act, right? So we all submitted comments a couple months ago, and this is actually pretty quick to see comments turned around from CMS. So they're talking to us about a couple things, and there's some that we're not going to talk about today because we don't have time, and things that we are going to talk about today. So, number one, we're going to talk about the part that everybody always forgets about in the Inflation Reduction Act, which is, I guess, the government's favorite thing, because we've already talked about it twice today, inflationary drug penalties. So we know Medicaid has them, 340B has them, Medicare has them too. And so the same logic, if the drug price increases faster than inflation, there'll be penalties. With Medicare, they are limited to single source products. So it's got to be a brand, a single source generic, or biologic, including biosimilars. Okay. So, and then there's this other piece, which is interesting. If it costs less than $100 a year for their member to receive that medication, they don't care how quickly you raise that price because it's very affordable in their mind. And so they're not going to charge you a penalty. So the other part, which we're all thinking about all the time, is these negotiated drug prices. And those do come into effect January 2026, and you've heard lots of people talking about that, but that is not what we're talking about today, okay? So, things to know about, right? So, estimates say that there is, these inflationary rebates could be $15–16 billion a year that Medicare could collect from drug companies. So they have to figure out how to get that money back. And they have timelines that are written into the legislation for when they have to have invoiced. And so for Part B, they are supposed to submit for those rebates quarterly, but the first invoice that they have to submit, they do have this flexibility for it to be September of 2025. And then for Medicare Part D, they're going to be looking at rolling years. And so those And that has to do with how they're calculating their rebate for it. For those, they don't have to submit their first invoices until the end of 2025. But they have some timelines that CMS has statutory accountability to make sure that they are actually submitting and collecting. And there were some government studies where they were trying to figure out how are we going to do this? And this is it. This is the moment where we all learn how are they going to do it. So proposed rule, surprise, we already knew this one. They came out with this last year. We've been seeing this evolve. In classic CMS fashion, they only talked about hospitals when they used their language, but key is for this year, still JG, TB, it's your choice. And next year, it is going to be TB only, okay? That's the key on this slide. So remember, if your hospital is still using JG, you must convert to TB by January. Okay, so here's the new part. They have to also collect these rebates on Medicare Part D, right? How are we gonna do this? And so let's see, I feel like my slide might be slightly out of order, so don't look at that. Let's look at this, and nope. Uh-oh. Let's see. Oh, yeah, I guess we're okay. I guess it is there. Yeah, it is there. Sorry, I rearranged my slides. Okay, so here's the gist. They said, we hear you. I guess it's this one. We hear you loud and clear. Thanks for the feedback, guys. Everybody told us modifiers are not going to work. They're not going to work prospectively, okay? Heard it from covered entities, from pharmacies, from PBMs. We heard you. Not going to work. And they did reserve the right to potentially do that again in the future, but they're not going to be doing that now. Okay, so what are they going to do? From 2026, 2027, that's when they are by law required to prevent these, to start removing them from the calculation. They're going to use a surrogate calculation, and they have said in this regulation that they have been granted the authority to do so. And so they've said they are going to take an estimate of the 340B purchases in the marketplace, of the 340B units in the marketplace, and then they're going to compare those to the total units sold in the marketplace, as far as retail pharmacies where the Part D is sold, and they are going to come up with a reduction calculation and remove those 340B purchases. They have suggested that they will work with HRSA and the 340B Prime Vendor Program, being the most complete single point of reference for 340B information of units sold in the marketplace. To create that surrogate calculation. In the document, they recognize that there are limitations to that, things like direct sales from manufacturers and ADAP programs and certain covered entities who choose not to participate in the 340B PVP program. But overall, they have the majority of the information in the space. So there may be places where it is an underestimate. There also could be places based on how they've suggested the calculation that it could be an overestimate, but we won't get into the weeds there. But here's an example of how it would be calculated. And so if there were 5,000 units sold in 340B, 50,000 units sold in the retail marketplace, and that would be 10% of the whole retail marketplace was 340B, then we would assume out of 1,000 units sold to Medicare that we would take out 100 of those units, and so only 900 units would be submitted for the rebate. So we've already talked about that. And then the other thing that is exciting in them hearing what we said, that we can't do these prospective modifiers, is that they're proposing from 2028 and going into the future, a repository. And the difference between a repository and clearinghouse, because that's really the key here, is a clearinghouse is making decisions, right? A clearinghouse is getting all information and saying yes or no, or maybe this wasn't right, right? And so a clearinghouse may have good claims, bad claims, non-compliant claims. And in the repository situation, they are saying, think Oregon model. They're saying, give us only 340B claims, and we're going to give you 90 days after the close of the quarter to submit to us, covered entities or your delegate, to submit to us 340B claims. And we are going to remove those from the calculation. And this is how we plan to handle it. Either CMS will do it, or they may have a contractor. They have lots of language in there about how they're thinking about doing it. The data elements are very simple. Pharmacy NPI, information on what fill it is, a reference number for the prescription, data service. I'm surprised they didn't ask for NDC. I think that would have been easy for them to ask for us to provide. Might include that in a comment, just so that they have one less item to crosswalk. And then they're also giving us a pathway to reconcile. So say something that went into the database, we did have to reverse a claim, correct it. There are, there's an 11-month reconciliation period after things close out for Part B, less of a concern for most people. There's 11 months and 36 months for Part D, but they're asking for comments on when we would provide reconciliation information to them. So that is everything. 2 minutes over, not terrible. All right, Mike. I'm gonna take
all good, Felicity. Plenty of time. Thank you for that. That's packed with useful information. So that was great. I know Rachel's been gathering the questions for you, Felicity. So while she brings those up, I have one question myself, Felicity. Going back to the the state level legislation, we've had a couple of questions come in from some clients over the previous few months. If someone is working closely with the state level associations, who do they call to get language?
So I will say that there are lots of different legal firms out there. We have seen most success personally with our covered entities, working with Powers Law Firm. I hate to kind of pick and choose one, but they have been very involved in states that have both had drafted successful language and then also litigated successfully as well. I do think that there are lots of really great 340B law firms that are out there. I'm just speaking from our experience of who we've seen successfully drafting and defending. I hate to pick a favorite, but
they've been good at it. That's okay. That's okay. That's good.
No,
good suggestion.
Not part of their company, but they have donated a lot of time to CV340B, who is a nonprofit that focuses on advocacy.
Excellent. Good. Okay,
right.
Rachel, you want to
I'll
kick
jump
it
right
off
in.
here with Q&A? Okay, go ahead.
So if there are any additional questions, feel free to email us and, we'll pass those through to Felicity. And so the first one that came in is, what should we do if on ESP we make a designation, but on the eligibility form, it says not eligible, but then on the wholesale accounts, the contract's loaded? Is it safe to unblock scripts to be accepted?
Yeah, okay, so that's a great question. So the wholesaler could not get the account unblocked if ESP didn't actually release it, okay? The ESP is the intermediary between the manufacturers and the wholesalers and communicating the information back and forth. And so we have seen instances where what is reflected in ESP may be a glitch in the system and is not up to date. So you can always check in with the support at 340B ESP or in the chat and ask them about what that discrepancy is. But if it has made its way to your wholesaler, that means that the transmission files, which are on the back end of the ESP system, has had you set up to be green lighted to approve your purchases. Otherwise, your wholesalers cannot get access to that.
Perfect. So how far back would you recommend allowing scripts in when you have a single designation and pricing is loaded?
Yeah, that is a very difficult question. I think that some of the changes that we've seen, Santa Fe, may have to do with uh, certain look backs. I know that there have been some out there who said look back to the beginning of a restriction, like 2020, et cetera. I would not encourage that. Some manufacturers actually do dictate how far you can look back. I typically am very conservative and say, once you've got it open, just keep going forward. Or, if you're going to do maybe a 1 month, I would not do anything more than a quarter. Otherwise, when you have anomalies in your purchasing, it creates interest from manufacturers beyond what you are looking for. And I do think that some of the changes that we have seen from manufacturers in allowing multiple sites to down to single may have had to do with people doing big look backs.
Gotcha. That makes sense. If I open an in-house pharmacy to combat the manufacturer's restriction, what's the average time to recoup my investment? Good
Okay, that's a great question. So I think that's hard, depends on what you spend, right? Like if you're renovating a space that you already have, that can typically be done more cost effectively than if you're building a brand new building. So what we typically say is that most 340B pharmacies will break even, but sort of before your startup costs, you should be at the point where you're breaking even on your operating expenses within your first year. And then you have to think about what were your startup costs. There are opportunities in the space to look at community grants. We have seen a lot of interest from different community foundations across states to help support local infrastructure, especially as places are becoming pharmacy deserts, to help open up pharmacies. If you're FQHC or another federal grant, you may have agency funding that might be available to you as well. But I think it's harder to say when would you recoup those costs because they can be so variable. Typically, we do, though, would expect that the pharmacy, for its operational costs, should be breaking even within that first year. I think changes in that 340B, cap, reimbursement, et cetera, might, and your payer mix, that makes a difference too, but.
For sure. Oh, you're going to love this one, Felicity.
Oh, I hear it.
Given the manufacturer restrictions and Genesis ruling, what are you seeing organizations do in terms of their patient definition? We don't want to adopt the full Genesis model, but we're curious what the happy medium is.
Yeah, I'm glad we brought this up. This is really important. Okay. So I'm going to talk about what are we seeing from HRSA, because that's what really matters. And I'm going to start this with, it's up to you, right? So the Genesis ruling. Okay, the Genesis ruling came back in favor of the covered entity and said that the way that the statute was written did not define patient. And so therefore we can use a plain text definition of a patient because the statute says we are not to sell or otherwise transfer our 340B drugs to an individual who's not a patient of the covered entity. So they said that the way that Genesis had interpreted patient was reasonable and that because HRSA was not granted regulatory authority over patient definition, they were given the Skidmore deference, not Chevron deference, which this is before Chevron got overturned, that they had to have the power to persuade. And HRSA had changed their mind multiple times, as was shown in the case. And so they did not win for how HRSA had been interpreting it at that point in time, which did not align with the published 1996 patient definition. Court did reaffirm the 1996 patient definition. Okay, so now we are all starting from the same point. Okay, so HRSA today, still operating off of the 1996 patient definition, still expecting us to show responsibility of care. And they are really, I would say, becoming more invested in how we are demonstrating the responsibility of care. There have been some audit reports that have come back that have said language to the effect that a shared medical record in and of itself, and a paraphrase, a shared medical record in and of itself does not constitute responsibility of care. And a scenario might be, an individual came to you 3 years ago for, some minor, very minor type of care. And this is a hospital situation, right, for an acute service, very minor acute service. And completely unrelated care. No, there's no completely unrelated care. Where 3 years later, you have access to a shared medical record and you have visibility to their prescriptions, that they would not consider that to constitute an ongoing responsibility of care. Typically within the hospitals, we have historically defined it as 3 years. But, if somebody came just for a vaccine or a lab draw, or, something that is, a blood donation, or, like those sorts of things where it's not, where we're not having these ongoing care relationships, I would be very cautious, especially, we've heard things like people who did mass immunizations in COVID, considering doing a 3-year patient definition off of those. I would absolutely not be doing that. If your doctor doesn't perceive they have a relationship with that patient, that's probably a good sign to you that your covered entity doesn't have a relationship with the patient. We're seeing that the Office of Pharmacy Affairs is very thoughtful about that primary care relationship or any other ongoing relationship where you can show you're continuing to see the individual and you have documentation in the chart to support it. However, just because you saw somebody once doesn't make them your patient for the rest of their lives. And then for hospitals, I think if you go back to the Morford letter, that context that was created in the Morford letter really informs where we see HRSA seem to be landing with hospitals. That if you say you saw a patient for diabetes in the hospital, that they're considering it to be appropriate to continue to do their prescriptions for the related diagnosis. But HRSA put some information on their website. They put up a new patient definition website within OPA. They also put some language up saying, hey, by the way, guys, we anticipate sending out some audit reports in the near future. And they anticipate a high level of findings in those audit reports. So everybody in the space is being very cautious. And so it's very important that as you consider an expanded patient definition, that you have a meaningful way of demonstrating ongoing responsibility of care. It is not just that you saw them, it's that you have in your policies and procedures a way to demonstrate you continue to have responsibility of care. We encourage everybody to make sure that includes updating your chart to include the newly prescribed medications if they're anything more than just acute.
Perfect. So there are a few other questions, but I want to be mindful of time. So what we'll do is kind of take these questions and create an FAQ, and we'll send it out to anybody who attended. So then we can, because we only got a minute left. So we wanted to thank you for taking the time to prepare slides and always fighting for 340B, because you are definitely a champion of 340B. So as we move forward, so please remember that our commitment to supporting you, our clients, remains steadfast. Whether you have any other questions, need guidance, or seek assistance with anything relating to 340B, we're here for you. So anything that you need, reach out to us or your client rep. And thanks again for joining us. And we'll send out the recording to anybody who wants that as well. And we'll also provide those slides too. So thanks again, Felicity. This was a ton of information and really good information. I don't know, Mike, if you have anything else you want to say?
No, that's it. It's a good wrap up, Rachel. And, just to echo the champion of 340B, Felicity, we really appreciate all the work you do behind the scenes that people don't see. So appreciate the time today, and all the clients who joined us. Appreciate it. And everyone have a great day. Thanks,
Thank
everybody.
you. Have a good day.
Bye, everybody.
Bye-bye.